it's likely.
But isn't that really a question of fact?
No.
As to whether or not
Good question.
the evidence is sufficient.
Good question. Because People versus Oster 67 Mishap says where there is no evidence of planning or motivation, bindover is erroneous. So no, it's not a question of fact. And it's a great question, but People versus Oster has already answered that for us.
You've already said, have you not, that even though it's a 6-second time frame, that could be, or a fact finder could conclude that that is sufficient time for the premeditation. Right?
Thank you. I've not said that.
Well, I know you're not saying that, but you are saying that the case law does not indicate that de facto says that there is not enough time because the time frame is not spelled out.
Right, the time frame is not spelled out. That doesn't automatically mean that.
Hannah Mackey, hearing within on behalf of Charles McLaughlin.
All right, very good.
Andrew Childers appearing on behalf of People, Your Honor.
All right. And this is a continuation of a preliminary examination, which I believe, I think it was Detective Rob was on a call that day.
That's correct.
Now he's here. And so you may call your next one.
Thank you, Your Honor. People would call Thomas Robb to the stand.
All right. Sir, please come forward to be sworn.
Take seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth? Have a seat.
I am.
State, spell your first and last name for the record.
Thomas Robb, T-H-R-A-B.
Sir, thank you, Your Honor. Sir, how are you currently employed?
I've been with Washington County Sheriff's Office.
And how long have you worked with the Sheriff's Office?
4 years.
Were you working in that capacity back on April the 5th this year, 2025?
I've been licensed as a road patrol deputy.
Road Patrol Deputy? Thank you. Directing your attention to around 7:30, 7:45 in the morning, were you in the vicinity of the West Willow neighborhood?
I was.
Okay. And on that date and time, what was your shift?
Sorry.
What was your shift that day?
I was working day shift.
Okay. What time did you start?
8 a.m.
8 a.m. Okay.
I believe the 7:30 time was when the call initially came in.
Okay. At some point, as your shift started, were you made aware of an investigation regarding a possible stolen Ford Explorer?
I was.
Okay. And who made you aware of that?
Deputy Phillips.
Okay. And what, if anything, happened in that morning on April the 15th that led to you being involved with that Ford Explorer in any way?
Deputy Phillips told me that he'd taken a stolen vehicle report from that vehicle. He advised that he had obtained GPS location for the vehicle from the victim. That it was pinging, I believe, on Brookside, which was in the West Willow neighborhood. He advised that he was going to go check the area for the vehicle and asked me to assist.
Okay. Were you and Deputy Phillips in the same patrol vehicle or separate patrol vehicles?
Separate.
Okay. To your knowledge, did Deputy Phillips arrive in the area of that suspected stolen vehicle before or after you?
Before.
Okay. How did you know that?
I heard him call it on the radio.
Okay. When you heard him call that out, where were you?
A few blocks away.
Okay. And what happened next?
After he called out that he was out with the vehicle, again, I believe it was on Brookside. I was a few blocks away. I heard mic clicks on the radio. That's pretty much when somebody depresses the talk button on the radio, but doesn't have a chance to get a transmission out. In my 7 years of doing this job, normally when I hear that, that tells me that the deputy's in trouble. There's some kind of accident that caused them to interrupt their transmission, whether they're chasing someone or fighting or something of that nature. So that gave me cause for concern. I continued towards that location where Deputy Phillips was at, and then I saw the, I believe it was 2024 Gray Ford Explorer. That was the vehicle in question. Speaking of the neighborhood.
So as you're entering the neighborhood, it's exiting the neighborhood?
Correct.
Okay. And what did you do next?
I recognized that it was the vehicle we were looking for. I believe Deputy Phillips was in danger or something had happened, so I activated my emergency lights and siren to try to stop the vehicle.
Okay. And did you have to turn your vehicle around?
No, I was coming right at the entrance to the side street where the vehicle, the Ford Explorer, was coming out from. So
okay.
Driving directly at it.
Got it. And did you in fact then begin a pursuit of that vehicle? Okay, and that started in this West Willow neighborhood?
Yes.
Okay. What is the speed limit on the road there where you initiated this chase?
It's a residential neighborhood, so 25 miles an hour.
Okay. Did the vehicle pull over after you activated your overhead equipment?
No.
Okay. What happened next?
The vehicle accelerated and tried to evade me.
And did you continue to pursue the vehicle?
I did.
And for how long did you continue to pursue this vehicle before it was eventually stopped?
I believe about 10 minutes or so. I don't recall exactly the time.
Okay. Where during that time, do you know, Detective Rob, what speeds did you get to?
I believe maximum speed was about 130 miles an hour.
130?
Yes.
Okay. What sort of vehicle were you in?
A Ford Explorer.
Okay.
It was a fully marked patrol car.
Thank you. At what point did this chase terminate in any way?
Van Buren police assisted us with the pursuit, and it was a Van Buren officer deployed stop sticks, which the stolen vehicle ran over, which caused, I don't know if it was one or multiple tires to deflate, and then the vehicle crashed into a berm at the entrance to a neighborhood. I believe it was on the end of any course roads.
And that's in Van Buren Township?
I believe so.
Okay. From the time period that you started this pursuit in the West Willow neighborhood to the time that it ended in Van Buren Township, did you ever lose sight of this Ford Explorer?
No.
Okay. After the vehicle was hit the stop sticks and crashed into the ditch, were you able to determine if the vehicle was occupied?
Yes, I was.
And were you able to see anyone in that vehicle?
Yes.
Okay. Are any of the individuals that you saw in that vehicle on April the 15th in the courtroom here today?
Yes.
Can you identify an article of clothing that they're wearing?
Yes, it was Charles McLaughlin. He's sitting to my left wearing a green jumpsuit.
And where, Your Honor, may the record reflect in court identification of the defendant?
Without objection, record shows so reflect.
And where in the vehicle did you observe the defendant?
He was exiting the driver's seat.
Okay. Was there anyone else in the vehicle?
No.
And what did you do at that point when you made contact with the defendant in the driver's seat of this vehicle?
He was exiting the driver's seat. I told him to show me his hands and get on the ground. He did. I placed him in handcuffs.
Okay. Did he appear to be injured in any way?
I believe he had some scrapes or bruising on his arms. Maybe, I think he might have had a small amount of blood on his lower lip, if I recall correctly.
Okay. Is it, do you recall, did like the airbags deploy in this crash?
I don't recall.
Okay. I have no further questions, sir. Thank you.
All right. Thank you. Cross-examination.
Good afternoon, Deputy Rob. You were in pursuit of the vehicle in question,
Yes.
and you followed that vehicle for around 10 to 15 minutes.
Around there.
And during that time prior to the accident, you got no closer than 50 feet, did you?
I got no closer
To
than,
the vehicle than 50 feet, would you say?
I don't know how close I got during the pursuit. I guess 50 feet might be accurate about closest I was, but I don't recall without reviewing the camera footage.
And you testified on direct that during the course of the pursuit, you activated your sirens. Is that correct?
Yes.
And at some point you were driving on the highway.
Yes.
Was it a busy highway?
I would say there was a medium amount of traffic.
So that means that there were other cars on the highway during the pursuit.
Yes.
And you had to make several lane changes to navigate through that traffic, didn't you?
Yes.
And some of those cars pulled to the side. Is that correct?
I'm sure some of them did. Well, usually people play not very good about pulling over.
And it would be safe to say then that some cars did not pull to the side.
Correct.
And at one point you had to even drive on the shoulder of the freeway. Is that correct?
Yes.
You don't know why some of the people did not pull over to the side, do you?
Well, without talking to them personally, no, I wouldn't know why.
So you don't have any personal knowledge then as to whether or not the drivers of the vehicles could hear the sirens.
I suppose so. Yeah, without talking to them.
So then it would be fair to say that you didn't know why those vehicles did not pull over.
I guess so.
And you don't have any personal knowledge that Mr. McLaughlin could or could not hear the sirens, did you?
I suppose not.
Thank you, Your Honor. No further questions.
All right. Can you redirect?
No, Your Honor. Thank you so much.
Sir, thank you.
Thank you.
Your Honor, with Detective Rob's testimony. The people have no further witnesses. The people press.
Any witnesses for the defense?
None for the defense, Your Honor. Thank you.
All right.
Now, people would move to bind the defendant over as charged on the information before the court. I believe it is 5 counts. Yeah,
Yes.
5 counts.
Mr. Brown responds.
Thank you, Your Honor. Your Honor, the court listened to the testimony previously from Deputy Phillips. It also heard the testimony from Deputy Rob. So the counts that we have that the prosecution is requesting for bind over are assault with intent to murder. That would be on Deputy Phillips. There's fleeing and eluding. That would be on Deputy Rob. There's receiving and concealing a motor vehicle, an unlawful driving away, and a resisting and obstructing causing injury. And I think that last one goes to Deputy Phillips. So I know it's been a bit, so we probably should go over what the prior testimony was. The testimony from the Deputy Phillips was that on April 15th, he was on road patrol. He'd gotten a call that referenced a stolen vehicle at the Marriott. He responded, had contact with the owner. The vehicle described as stolen was a gray Ford that was stolen sometime during the night. I don't know if we ever really narrowed that down to exactly what time that vehicle would have been stolen. That was entered into lien. At some point, they got to the cul-de-sac in West Willow, where the GPS told them that the vehicle would be found. They first got there, they couldn't see the plate because the vehicle was facing them. I believe that when they pulled up, they were facing the vehicle. They were probably, 20 to 30 feet away from the vehicle. Again, it was facing them. And while they may not have been directly head on, they were in front of them with their headlights facing each other. The officer testified, Deputy Phillips, that he could see that there were at least 2 people in the vehicle at the time, that they pulled up. But then once they came to a stop, they said they were going to conduct a modified felony stop. Deputy Phillips said he unholstered his pistol. 2 passengers then got out. And so 2 people got out of the vehicle. And they started walking away from patrol car as well as the vehicle that they were in. Said he couldn't see the driver at first. Later could see who the driver was at about 15 feet. Said he yelled to the driver to turn the car off. So I believe the car was still running at this time. This point, his weapon is drawn. He says that he stepped out away from his vehicle into a space. This is a cul-de-sac. And as the testimony was developed, there was a space between the front of his vehicle, where here's the passenger got out, and a space in the street from where a vehicle could pass through. He said he got out, couldn't recall whether or not he'd raised his hand, but he did get out and he got into that space. He said he could see the vehicle, the wheels turning, and that the car then drove at him without veering. He had his weapon drawn. And the vehicle, once it got started, did not stop, drove at him, clipped him on the knee as he had to jump to get out of the way of the vehicle. He did say that the vehicle does not stop after that. I asked him if the driver said anything to him. He said that there was nothing said, no threats made or anything like that. He did say he had recognized the driver as Mr. McLaughlin. He then testified that he and his partner then got into the vehicle and left in pursuit. So what we have then is the vehicle stolen sometime in the night. We do not know, or there was no testimony given as to who drove that vehicle away. We do know when the vehicle is seen again, there are three people in the vehicle. And I'm not clear as to how much time has passed. It's been a few hours. So we don't know if the person who took the vehicle, drove the vehicle away from the scene, is even in the vehicle when it's reached at West Willow, because there's been no testimony given for that. If the court remembers differently, certainly they could say, but as I recall the testimony, they spoke with the person who owned the vehicle and they simply said that the vehicle was taken in the night and they had a GPS and they're able to track them. So at the time that the officers or deputies are looking for the vehicle, tracking the vehicle, they have no idea who has taken the vehicle, male or female, white or black, fat or skinny, tall or short. There is no description of the driver or the person who actually drove away with the vehicle. We just don't have that. But what we do have is three people who are associated with the vehicle. One person's in the driver's seat, and several hours that have passed since the vehicle was driven away from the spot. So let's go back to the first charge, which is assault with intent to murder. So based on Mr. Chalice McLaughlin driving at the officer who was in the space through which the vehicle must pass in order to leave the scene, based on him driving at the officer and hitting him, the prosecution is charged assault with intent to murder. Now, most of the time we see this is usually charged as felonious assault. In fact, every time I've ever seen this, it's been charged as felonious assault. And there is a reason that it's charged as felonious assault. First, in order to prove assault with intent to murder, prosecution must show evidence which would have supported murder had death occurred. And that's first degree. They have to show that it was a first degree murder because they have to, in this, back up. This is People versus Sis Medea. That's 167 Mich 210. They have to show that their murder, that had death occurred, it would have been properly charged with murder. So, second, let's go with People versus Todd, 186 Mich App 625, 1980. There must be an intent to kill in order for you to have, for murder. For you to have murder, there must be an intent to kill. And this is what the prosecution is no doubt going to argue. They're going to argue, you know what, even if he didn't say, I'm going to kill this guy, I plan to murder this guy. And you have to have that. You have to have plan and motivation to murder. They're going to say, well, he created a risk so high that, and he knew the consequence. He knew if he hit this guy, he could die, that's going to be sufficient. And I think would be the logical thing to argue, that the risk that he created with the knowledge of the probable consequence, that'd be sufficient. But the law would not support that. People versus Milton, 81 Mishap 515, 1978. There must be some time for premeditation and deliberation. So remember, the court may recall that it was 6 seconds from the time the officer got out of his vehicle and stood in that area in order to stop this vehicle from leaving. 6 seconds. Now, the law does not define how much time you need for planning and premeditation. It doesn't do that. But it is clear where there is no evidence of planning and motivation. And they have to show that. They have to show some planning, some motivation to kill this person. What you've seen is a motivation to flee the area, perhaps. But there is no evidence put before this court that when this vehicle was driven at that officer, that the plan or the motivation, the intention or the premeditation was to kill anyone. And they have to show that. It's not enough that they show, well, it's likely.
But isn't that really a question of fact?
No.
As to whether or not
Good question.
the evidence is sufficient?
Good question. Because People versus Oster, 67 Mich App says, where there is no evidence of planning or motivation bind over is erroneous. So no, it's not a question of fact. And it's a great question, but People versus Oster has already answered that for us.
You've already said, have you not, that even though it's a 6-second time frame, that could be, or a fact finder could conclude that that is sufficient time for the premeditation.
Thank you. I've not said that.
Well, I know you're not saying that, but you are saying that the case law does not indicate that de facto says that there is not enough time because the time frame is not spelled out.
Right, the time frame is not spelled out. That doesn't automatically mean that it's an issue for the trier of fact, because they still have some duty, Your Honor, to show that there was some planning and motivation. That's what you're giving. What you would, if you were to bind over based on what you have here, you'd be taking away their duty. You'd be relieving them of their duty to put that evidence in, and that's what they have at preliminary examination. They have a duty to show that there was some planning. You can't simply say, well, you know what? Since the law says that, there's no time frame, then that's enough. They have to actively show that there was a plan, a premeditation to murder. It's not simply, well, you know what? And again, if you couple that with People versus Milton, where even the creation of a high risk of death with knowledge of the probable consequences is insufficient, that makes their duty very clear, Your Honor. They can't simply just toss these things out without showing exactly what they need to show, and that is that there must be some premeditation, some plan to do so. They have an active, affirmative duty to show that. They simply can't say, well, what he did was risky, and that's enough. They can't say, well, since there's no time frame, that's enough. They have to show you that there was a premeditation and a plan. And the most likely thing that was going on here was Mr. Jackson was trying to leave the area. The officer got into that area, and in the 6 seconds that it got for him to get out of his vehicle and to walk into that space where the vehicle had the only space where they could get by, and they ended up hitting him.
Premeditation necessary for first-degree murder implied where it involves a police officer?
There's no exception for police officer. There's no police officer exception.
No. But where it becomes first-degree murder, it's implied because there are certain types of acts that constitute first-degree murder.
Right.
Right. One of those would be the potential killing or the killing of a police officer, where the premeditation is implied.
So you're saying there is an exception for police officers with acts that
I'm not saying it's an exception. I'm just saying there are certain things that will constitute implicit premeditation from the standard definition.
So you're saying that there is a police officer, something that specifically.
I don't know if you want to call it an exception. I'm saying that there's something unique as to police officers, such as it would be where a murder occurs during during a first-degree CSC.
That's a felony murder consideration, Your Honor.
Well,
and I don't.
It can be, it can be that. But even when you're talking about it being murder, what you're doing is you're implying the premeditation necessary.
Because it's a police officer, so forth. So what you're saying, in some clear.
I asked the question, isn't there an exception?
I do not believe there is. I do not believe that the law changes. And that's equal protection. My client is entitled to equal protection under.
I don't think it has any equal protection implication. It's just a question of whether or not under the statute that gives that there is an exception.
Well, it is
equal protection. An exception.
It is equal protection in that my client is entitled to, and again, I don't believe that this exists. Certainly, we can research it if the court believes that actions.
I just asked the question.
Well, okay. So my response is, I do not believe that that is a thing. I do believe that that's a thinking and charging what in every other case is always charged as a felonious assault. I do believe that there's a thinking, and that's where the equal protection comes in. That's exactly where the equal protection comes in.
I don't know.
Because my client is.
I don't know if that's equal protection.
Well, I'll explain to you why I think so.
Well, I don't need it.
Okay,
Because I
well,
don't think
you've rejected it up front. Okay,
I
fine.
rejected outright.
Okay, all right, fine. Well, Your Honor, then I have to say I reject the notion that police officers have some sort of protected status.
Well, you could reject it. I asked the question. You're saying
Okay.
no.
I'm saying
I'll
no.
hear from the
I'm
people
saying-
when they get to
When they
that.
get there. Okay, all right. So let's move past that. Let's go to the unlawful driving away. Now, as I recall the evidence coming out, and the court may remember differently, there was no identification of who drove that vehicle away. And for unlawful driving away, the person who drives the vehicle away, or
Yeah, but yeah, I hear that argument, but does it matter whether it was driven from the scene or from the hotel? Is it really going to matter?
yes, because one is receiving and concealing stolen goods and one is driving away. The thief has to drive the vehicle away. If they put no evidence before you, let me back it up. Sure, you can certainly say that recent possession of stolen goods leads to the inference that a person knows the property is stolen. It does not lead to the inference that the person stole the property. And they have to put evidence on that Mr. McLaughlin drove that vehicle. That's why it's called unlawful driving away, Your Honor. It's not unlawful possessing later on. It's unlawful driving away. You can't conflate receiving and concealing with unlawful driving away. They have a duty
Well,
to.
the person, so what I'm saying is whether or not he took possession at the hotel or whether or not he took possession at the cul-de-sac, because he was driving the vehicle, and there's testimony to that,
Yes.
he took possession and he's driving it away.
That would be at most unlawful. That would be receiving and concealing stolen property, Your Honor. Unlawful driving away means that he has to have taken the property knowing that the property was not his, that he was taking the property from the owner. You don't know that he was at the hotel. You can't, and that's.
I'm just saying it won't matter where you start, though. I'm not saying that there's an indication that he necessarily took it from the hotel. If you concede that point, I'm saying the unlawful driving away can happen at the point of the cul-de-sac.
Then how do you get receiving and concealing stolen property? How do you distinguish the two if you're going to say it's always a?
I'm not here for reasonable doubt. I'm not here to answer your questions. So you can go ahead with your argument.
All right, so let's make sure that we're clear on that. Unlawful driving away demands that the person take possession of the vehicle, in contradiction or in contrast to the owner. If he takes possession of the property from someone else who stole it, he's not an unlawful driver away of a vehicle. He may be someone who receives and conceals. The problem for the prosecution's case, Your Honor, is they have not established who took the property from the owner, or at least where the owner had the property last. And they have to do that. Just because you can say that he was in the vehicle later does not and cannot support a UDAA. At best, it can support a receiving and concealing of stolen property if you go with the thought that recent possession of stolen property, knowledge that the property itself is stolen. But it does not support a claim that the person, whoever is in possession of it, actually took that vehicle. And that's what UDAA demands. They have to have taken the vehicle from the possession or control of the owner, even though it's in the parking lot and the owner may be elsewhere. They have to have taken it there. If they drive it later, at best, that's a receiving and concealing. It's not a UDAA. That's not what the law says for UDAA. If you argue something differently, then always, if someone steals the car, hands me, and that's another thing too. There's not been any evidence put on that my client had the keys or didn't have the keys. But even getting past that part, getting past the notion that someone may have given him the keys elsewhere, I can concede that it's relatively recent possession, even though we don't have enough time or we don't have a specific time period. How long the vehicle was taken or when my client would have come in possession of that vehicle. And that's important when he comes in possession. If someone else steals that vehicle and hands him the keys or hands him whatever, you cannot say that he drove that vehicle or that he unlawfully drove the vehicle away, because that has to come in against the owner's possession and control and not against someone or anyone else's possession and control. We don't know that any of the other two passengers didn't take that vehicle away, at least not from the evidence that's been presented here, that any of the other two passengers didn't take the vehicle and then give him possession later on. And that's important. So, with respect to the 2, 3, and 5 counts 2, 3, and 5, I believe that those are in fact issues for the trier of fact. With respect to count 1, I don't believe that the prosecution has met its burden of proof. And if the prosecution can get up and say that there is an exception for police officers, as the court suggests, and they can cite some case law.
I asked the question, Mr. Brown, so don't put words in my mouth. I'll hear from them.
All right, fine. So, and also with the UDAA, I don't think they've met their burden there.
Response.
I'll start with the assault with intent to murder. So looking at the jury instruction 17, and Michigan pattern criminal jury instruction 17.3, assault with intent to murder requires the defendant tried to physically injure another person. Second, that when the defendant committed the assault, he had the ability to cause an injury or at least believe that he had that ability. And third, that the defendant intended to kill the person and the circumstances did not legally excuse or reduce the crime. Intended to kill the person, not intended to commit first-degree murder. That's a very different thing. And looking at People versus Erickson, a Michigan Court of Appeals published case 288 Mishap 192. This is from 2010. Specifically states this points to this jury instruction as the elements of assault with intent to commit murder. It is not assault with intent to commit first-degree murder. It's just assault with intent to commit murder.
So I don't even need to address that issue, whether there's an exception
There's nothing in the jury instruction
that requires that. Okay.
And so then we're left with the question of is the defendant in driving a Ford Explorer at Deputy Phillips intending, can you infer from that behavior an intent to kill? And the argument before the court that the people would put forth is when you're piloting what is probably a 4,500 or 5,000 pound object, accelerating and pointing that vehicle at an individual, you absolutely, that those actions, there's a logical inference that can be argued that would create a question of fact that you're intending to kill that person. That's a mass, we're not talking about a motorcycle or a scooter or a golf cart or anything else. We're talking about a Ford Explorer. This is a large vehicle. The defendant looked, based on the testimony of Deputy Phillips, he was looking right at him. Deputy Phillips is attempting to get him stopped. He steers in the direction of Deputy Phillips, hits the gas, and hits him. Now, granted, Deputy Phillips was able to get out of the way, and it only struck his knee and kind of fell to the ground. But we have to consider the actions of the defendant, and I think to a probable cause standard, there is certainly a question of fact as to the defendant's intent. But unequivocally, if you take a Ford Explorer and you floor it and you aim it at someone, you can kill them. That is just common sense. Regarding the UDAA, again, relying on the jury instructions, unlawful driving away out of automobile requires first that the vehicle belonged to someone else. Second, that the defendant took possession of the vehicle and drove it away. And third, that these acts were both done without authority or without the owner's permission. Fourth, the defendant intended to take the vehicle without authority, knowing that he or she did not have the authority to take the vehicle and drive it away. As the court alluded to, that doesn't require that you must take the vehicle from the first place it was stolen. Now, I think that there's a logical argument and facts such that the location of the hotel versus the location of where this vehicle was found and the time frame that it happened at some point overnight, and this is 7:30, 8 o'clock in the morning. Again, there's a logical inference, circumstantial evidence to suggest that the defendant did in fact take that vehicle from the hotel parking lot. We're not talking about one state over or 200 miles away, something to that effect. But I believe that, again, there is sufficient evidence before this court to a probable cause standard that there is a question of fact regarding that count. And I believe the defendant should be bound over on all 5 counts.
All right. Okay. With reference to, there is no dispute as to a bind over on count 2, 3, and 5. Therefore, the court also does believe that the people have sustained their burden and the defendant would be bound over on counts 2, 3, and 5. without objection as they raise issues of fact. In terms of the unlawful driving away of a motor vehicle, again, it would be this court going into the province of the jury as to when they first saw the defendant in the vehicle. Certainly a jury could reasonably infer from the hotel, the timing and everything else that it was indeed the defendant who did that. I don't think that people have to go beyond that. So certainly under that, if the theory is correct that it's got to be taken from the location from the owner, but I don't think that that's correct. But still, even then, I think a reasonable fact finder could conclude that. As it relates to the other piece of that, I think an individual can be charged with the unlawful driving away of a motor vehicle when they took possession or assisted in taking possession of that vehicle. I don't think it excludes, it doesn't get charged or can't be found to the exclusion of something else, a receipt and concealment. Certainly a reasonable fact finder could conclude that the defendant did, even at that location, take and or assist in the taking of that vehicle and its unlawful driving away. So that charge would be proper, and a fact finder could conclude that. So the court would bind the defendant over for those reasons on count 4. With reference to count 1, the assault with intent to murder, I also do not believe that it requires first-degree murder and some premeditation within that. It is really the intent to kill, as the instruction indicates. But even though I do believe that if it were to require that, I think that premeditation is implied within the actions of the defendant because of what was happening, and there's no equal protection argument regarding that. However, very clear in the testimony where a reasonable fact finder could conclude the intent was Deputy Phillips' testimony that as he's there, the wheels of that vehicle are pointed right at him as it's accelerating out. It's not a circumstance where they were trying to go around him, they were trying to do whatever. And certainly a reasonable fact finder could conclude that that was an attempt to strike and kill Deputy Phillips. And that, as it then relates to count 5, maybe by the grace of God, Deputy Phillips gets out of the way. His leg is hit and injured. But that would, even though he's able to do that, that doesn't necessarily negate the intent that the defendant, or what one could find as the intent to kill in this case. And the court believes that there is sufficient evidence as it regards that under either theory of the first-degree murder or under the notion of kill. I think there's sufficient evidence to go forth to a jury on that charge, and therefore the court would find that the people have sustained their burden and bind the defendant over on count 1. So to conclude, the defendant will be bound over to stand trial on all 5 counts. Now that you see the information waiver treating.
Yes, sir. Now that you see the waiver treating for the record, I'm going to enter a plea not guilty.
And having waived formal reading, pleading not guilty as to all counts, court will enter that plea. Pretrial will be set for
August 13, 2025 at 1:30 with Judge Conlon.
August 13, 2025, 1:30, Judge Conlon. Bond will continue. Thank you.